The Joint Committee on Administrative Rules will come to order. Clerk, please take attendance.
Representatives Hadsma,
Here.
Liberati,
Here.
Carter,
Here.
Beerline,
Here.
Beeler,
Here.
Senators Wojno,
Here.
Byer,
Here.
McMorrow,
Here.
Tice,
Here.
Runestad. Mr. Chair, you have a quorum.
Thank you. The first matter is adoption of the rules, which the clerk has shared with members. May I have a motion to adopt the rules?
So moved.
Senator Wojno moves. Would the clerk please call the roll?
Representatives Hadsma,
Yes.
Beeler,
Yes.
Senators Wojno,
Yes.
Byer,
Yes.
McMorrow,
Yes.
Tice,
Yes.
Runestad. Mr. Chair, you got 9 yeas, 0 nays, 0 passes. The motion prevails.
Thank you, Mr. Clerk. Next item of business is a presentation from Timothy Reeves and Rachel Huggart from the Legislative Services Bureau.
Thank you, Mr. Chair, committee members. I am Tim Reeves, an Assistant Director of the Legal Division of the Legislative Service Bureau, and with me is Rachel Huggart. We are both primarily drafting attorneys, but get called into duty once in a while to do something with regard to JCAR. And I was asked this morning to give a presentation. I understand it was to be about the function of JCAR. So I have a short slideshow here for everyone's enjoyment. And I've asked Rachel to kick me underneath the table if I start going on too long, droning on too long about this. But JCAR is, I believe, the only statutorily created committee in the legislature. It was first created in 1947, generally to act as a committee that met between sessions, back when, in the days when the legislature only met part-time. And it was to review administrative rules, and if it found any administrative rules objectionable, to put them on hold until the next session of the legislature. That continued for a while, although there was some controversy about whether that was constitutional. Its power was reduced in 1958. In 1963 Constitution, that power was specifically put into the Constitution. In 1977, over the veto of then Governor Milliken, JCAR's powers were greatly expanded. And JCAR was essentially given a legislative veto power over administrative rules. And that was a pocket veto, essentially. If JCAR did not approve the rules, they did not go into effect. That continued for about 20 years, and up until the mid-90s, when there was litigation about that after the Engler administration filed some rules that JCAR had not approved. So that's a little background, which brings us up to the Blank decision in 2000 and some amendments that the legislature adopted limiting the power of JCAR in 1999, which takes us up till today. There are 5 things, basically, that JCAR can do under the current statute. First, this slide shows the entire rulemaking process, and I'm not going to go through it. It starts with a request for rulemaking that the agency submits to MOHAR, the Michigan Office of Administrative Hearings and Rules, and ends with JCAR reviewing the rules. I have been told that the average time for this process is about a year for a rule to go through the entire process, although some of the rules take longer, some go shorter. But JCAR is at the very end of this process. Under the statute, the JCAR has 15 session days, which is defined in the statute. A session day is a day when both houses of the legislature meet and record a quorum. So there doesn't have to be any voting, but there does have to be attendance and a quorum recorded. That is a session day. 15 session days that JCAR has to review rules. During that time, JCAR can first do nothing. If JCAR does nothing on the rules may be presented to the Secretary of State, and then they are promulgated and take effect. Second thing that JCAR can do is waive the session days. And then if JCAR waives the remaining session days, then those rules can be filed and take effect right away. Another thing that JCAR can do is propose that a rule be changed. That is a more recent amendment to the Administrative Procedures Act that was added in 2016. JCAR can object to the rule, and that is something that was adopted back in 1999. Or JCAR can decide to introduce bills to enact the subject of the rule into law. And again, that's something that was added in 2016. All of these, just by way of background, the blank case said that the previous procedure, that is JCAR having a pocket veto and the right to review, approve, disapprove any rules, that was unconstitutional. There have been no challenges to the statute as it has existed since 1999. So don't know what a court would think of the current procedures that are in the statute. I'm going to skip to this slide, which is object. This is what has been in the statute since 1999. JCAR has to object. All of the actions by JCAR have to be done by a concurrent majority of the committee, that is at least 3 members of the Senate and at least 3 members of the House. To object, JCAR has to find one of these statutory grounds for the objection. I'm not going to go through and read them all, but there are 7 statutory grounds for an objection. If the objection is approved, then the members are required to introduce a bill in both houses, a bill that would rescind the rule on its effective date, repeal the statutory provision under which the rule is authorized, or stay the effective date of the rule for up to a year. So that's introduced bills. Under the statute, the bills have to pass both houses within 15 session days again. And then since they are bills, they go to the governor for potential veto by the governor. So this is the procedure that was put into the statute in 1999. To my knowledge, I looked into it a little bit. I think this has only been done once or twice. Bills were introduced and never moved in the legislature, but so it has been done. One of the things that was added in 2016 is that JCAR may officially propose that a rule be changed. If JCAR proposes that the rule be changed, the agency has 30 days to decide either to change the rule and resubmit it or decide not to change the rule. If they decide not to change the rule, another 15 session day period starts. This was done one time, and that was last year with rules of the Secretary of State. regarding elections, that the rules were returned with recommendations on requests for changes. I believe the Secretary of State made maybe one of the recommended changes, not the rest. And the other thing that JCAR can do, last thing, enact the subject of the rule into law. So the committee chair and the alternate chair must introduce or cause to be introduced in both houses bills to enact into law the subject of the proposed rule. And then the rule is put on hold for 270 days under that provision. And again, that happened last year with those Secretary of State rules. And there was no challenge to that. The Secretary of State waited until the end of the 270 days, the end of the year, to promulgate the rules and filed them, and they went into effect. And that is basically my presentation. Those are the things that JCAR can do. We are always here to answer any questions that anybody has and be glad to entertain any questions if there are any this morning.
Committee members, any questions of Mr. Reeves or Ms. Hughart? Thank you. Next, we will hear from the Department of Treasury on their proposed rules on sales and use taxes submitted to this committee on June 21, 2023. And the department's request that this committee take action to waive the remaining session days and allow those rules to take effect. Good morning. Ms. West, and I don't have the other witness's name.
Sure. We'll do an introduction. Thank you for having us,
You're welcome.
Chairman Hodsman, members of the committee. My name is Amanda West, and I'm the Legislative Director at the Department of Treasury. I'm here with my colleague, Dave Metelsky. He's an administrator in the Tax Policy Division. We are here to discuss the proposed general sales and use tax rule changes, and given the continuing need to provide guidance in response to the requests and needs of the business community, we respectfully request that the committee waive the balance of the session days and the review period. The current general sales and use tax rule set contains over 80 rules, many of which were promulgated in 1979 and have not been amended since. As you might expect, there have been significant changes to Michigan sales and use tax laws since then due to both legislation and litigation, which have rendered many of the rules obsolete in whole or in part. The current update to the rule set before you began 6 years ago in 2017 when the Michigan Chamber of Commerce contacted the Department of Treasury and requested that it undertake a project to clean up and rescind the rules that are obsolete and inconsistent with existing law, which serve no purpose other than to create confusion. That contact kicked off a project that has taken years, subject to interruptions due to substantial federal tax reform and the pandemic, but is now nearly complete. Throughout the process, the Department of Treasury has worked collaboratively with its stakeholders, including the Michigan Chamber of Commerce, the Michigan Association of CPAs, the Manufacturers Association, the Retailers Association, the State Bar of Michigan, and the Michigan Automobile Dealers Association. This included an iterative process of drafting or rescission, sharing comments and meetings, many meetings as I've learned, to discuss any issues or areas of disagreement. The rule set now before you is the result of that lengthy process. If promulgated, this project will result in the amendment of nearly 30 rules, the addition of 2, and the rescission of nearly 45 others. Additionally, there are no known objections to the rules at this point. Our team is more than happy to field any questions that you may have, and we thank you for your consideration.
Thank you, Ms. West. Are there questions of the committee? And Representative Beeler.
Thank you, Mr. Chair. I just have 2 quick questions. Appreciate that you made mention of the collaborative effort that you've had with the business community. To your knowledge, are those coalitions or are those associations, are they supportive of this rule set before us, or were they just brought to the table throughout the drafting process?
I'm not sure, Representative Beeler, what cards of support or opposition have been put in. I know they were supportive of the process. Our rule set Many of these rules, as you can see, date back to 1979. There's been substantial changes, both statutorily and through case law developments. And I know that the business community was generally supportive of us cleaning this rule set up and getting rid of a lot of these outdated rules that were, as Amanda mentioned, just causing confusion out there.
Okay. And then my second question, do we know for certain, or could you help clarify, at least from my perspective, if any of the rule changes, cleanups, anything that is being done today is going to cause a business or an individual to have to pay a tax on something that they are not currently? In other words, will someone have to pay tax on something after these rules go into effect that yesterday they were not required to?
Thank you for that question. No, I don't believe so. The main driver of what we were trying to do here was to make the rule set consistent with the statute and consistent with case law. To the extent that there's been any sort of conflict that's developed because of statutory changes or through case law, those cases and those statutes control over our rule set. So like right now, we currently have a lot of the rules we're rescinding. Many of them are not consistent with the statute. And so to the extent they're not consistent with the statute today controls, and it'll still control once this rule set comes through.
So this should not increase the number of things that people are paying sales and use tax on?
No.
Okay. Thank you, Mr. Chair.
Senator Tice.
Thank you, Mr. Chair. Thank you for bringing this forward today. It's obvious that there was a lot of work involved in it. When was this submitted to JCAR?
I don't know the exact date. I believe it was mid-June. I want to say June 21st.
Thank you, if I may continue. How many session days have occurred since it's been introduced?
I'm not sure the answer to that question. I'm not sure if any have, since it requires both chambers to have a quorum. I know we've had each chamber here individually, but I'm not certain of if any have passed.
Thank you. I appreciate that. And now to get into the detail of it, if I may. And it just, some of it's just simple. On page 2, you reference 2 or fewer sales that are not for fundraising purposes. Is fundraising defined in statute or somewhere else in the rule set? Is it defined different ways in different areas of statute?
So I think what you're referring to is subsection 7, subsections A and B.
Correct.
And really what those are is, no, that's not defined in statute, but what those two concepts are really getting at is the statute provides that a taxpayer shall register, somebody who's making retail sales shall register and file monthly sales and use tax returns. But there's also a provision within the statute that allows the department to prescribe a different filing period if it thinks it'll be more efficient for the taxpayer and the department to prescribe that different filing period. And this is really a codification of a longstanding position that the department's had for folks who, if they're having 2 or fewer events, they don't need to go through the process of getting registered and all of those things. They can just grab one of these 2 forms and remit the sales tax that way rather than having to bother being registered and filing monthly returns.
Thank you. I understand what the intention was of it, but literally every sale is for the purpose of raising funds, fundraising, raising funds. So I'm concerned that it could at some point be, if it's not defined, misunderstood. And I have similar questions that go throughout, but obviously I don't want to take control of the entire meeting. I have concerns that because this is so expansive, that there are a lot of organizations that this will touch who haven't yet had the opportunity to see the final product. And that raises significant concerns because it's so broad. It literally describes the taxation of guinea pigs. So I'm concerned about that. Thank you.
Okay.
Senator Bear.
Thank you, Mr. Chair. Also, for clarification, then, everything that's in the set of rules that we're looking at today are things that are already prescribed either in case law or in statute. So there's really nothing new in here that's not already been in effect for all of our customers, all of our constituents. Yes?
This part is not in the statute. I'd have to look. I don't have the bold strike through to know if this was in the rule prior. But this is a long-standing administrative process. We've had these forms available and this standard as far as remitting tax in place for a very long time.
Yeah, so the issue is, have people seen this in the past? These are things that are already in existence. That's the clarification.
Correct.
Yes? Okay, thanks.
Senator McMorrow.
Thank you, Mr. Chair. Addressing, I think, both of the previous comments, can you walk us through the process, what the process would be should there be a customer, somebody doing fundraising who may have a tax levied upon them because the new rules are misinterpreted? What would be the recourse for somebody, an unintended consequence? We know that this is going through to kind of clean up existing statute, make sure that the rules align with existing statute. But what if there is somebody, a local tax collector, who might misinterpret something?
So there wouldn't be any local tax collectors because all of our sales and use tax is administered from the state level. But the consequence would really be if somebody, say you use this form and they're having lots of these events, and they're exceeding that too, the consequence would just be that they would just need to get registered and they'd be put on a filing frequency, either monthly, quarterly, or annually, depending on their sales volumes, and they would just have to remit on those returns and do it that way instead of through these kind of special forms we have for these people who really just have an event or two per year.
For the purposes of this committee, if there was a specific line within the new rules that was maybe misinterpreted frequently, would it then come back to JCAR for us to reassess and maybe make a change?
I don't know how it would come back, but if we were receiving a lot of feedback that one of our rules were confusing, we certainly would look into making changes to that rule to clean it up. And we can also explore other forms of guidance where we don't have to go through such a long, year-long process, as was mentioned in the previous presentation, where we can provide some more guidance to taxpayers to help answer those questions.
Thank you. I appreciate it.
Thank you, Senator.
I have one question, I think. Are these proposed rules in any way in conflict with existing statutes or existing appellate case law?
No, they're not, Mr. Chair.
Thank you. I'll entertain a motion now to waive the remaining session days on rule set number 23-69. Senator Bueno has made that motion. Would the clerk please take the roll?
Representatives Hadsma,
Yes.
Liberati,
Yes.
Carter,
Yes.
Beerline,
No.
Beeler,
No.
Waino.
Yes.
Sorry, Senator Waino,
Yes.
Byer,
Yes.
McMorrow,
Yes.
Tice,
No.
Runestad. Mr. Chair, you have six yeas, 3 nays. It prevails.
Seeing one absent member, I entertain a motion to excuse that absent member. We have that motion made by Senator Baer. There being no further business before this committee, the committee is adjourned.